to this interview for Big Data and Society. Today we have the great pleasure to interview Professor Luciano Floridi from the Oxford Internet Institute on his role in the Advisory Council to Google on the right to be forgotten. And it's our great pleasure that he's with us today, and I'm going to turn around the camera now. So can you tell us a little bit about the role of the Advisory Council? How it was formed, what is the role, what are you doing basically there, how were the people selected, etc.
So thank you for the invitation. The Council is going to address the problems caused by the right to be forgotten, the so-called right to be forgotten, namely the ruling by the European Court of Justice, which indicated that search engines, Google in particular, are supposed to, or are expected to remove links when requested by, to do so by individuals whose personal information has been linked by the search engine and is either inaccurate or no longer relevant, and therefore affects their privacy. The role of the Council is to basically deal with 2 points. One, understand the issue, and two, find a approach or strategy to deal with the consequences of the ruling. Understanding is important because the ruling has left things rather unclear on many sides, and the approach or strategy is also vital, because at the moment we have search engines, again, in particular Google in Europe, as gatekeepers of some of these links and the decisions behind the removal, a situation that everybody finds unsatisfactory. Now, how the Council was put together, I'm not sure about the other members. I was certainly personally invited. It came pretty much out of the blue as an invitation. I was at a conference in Crete when I got an email, and then some following telephone calls in terms of interaction and contact. I suspect that the interest in my role and expertise came because of the previous interaction I had with the European Commission when I was dealing with a project in 2013 on the impact of ICTs on European society from an ethical perspective. I also suppose that there was need for a ethical understanding of the issue. I'm the only philosopher, the only ethicist in the group, and I guess I cover that particular corner of the complex problem.
What will be the expected result of this initiative?
So the concrete deliverable, to use a more European Commission's terminology, is a final report which will contain the consultations and the results we have achieved by listening to a number of experts throughout Europe. That will involve 7 meetings in 7 European capitals. We have already done 2 meetings, 2 public consultations in Madrid and Rome. The following ones will be in Warsaw, then Paris, Berlin, London and Brussels. So it will contain basically the material collected through the consultations. Then there will also be an outline of the understanding and the strategies that I highlighted before, and of course any point of disagreement that might have occurred either individually or as a group among the 8 of us, 8 experts who are, as you may expect, completely independent, and by the way, not paid by Google either.
Can you tell us a little bit about these public consultations, because the first ones you just said have just happened recently? So what is happening during these council meetings or during these public meetings?
Yes, these are organized as consultations of experts, 8 experts per meeting, or at least the format that we have adopted so far. The experts are selected among individuals who have expertise on the topic, either from the legal perspective or from the civil society perspective, hopefully from the legislative and the policy-making perspective as well. We shall see how we progress. But the expectation is that the experts will provide answers to 5 specific questions that we provide, which are attempts on our side to understand better the problem itself. The experts have about 10 minutes to present their answers to these questions and their perspective on the ruling and especially the consequences and what Google in particular should be doing in the foreseeable future. Then there is a question and answer section when we ask more questions and clarification to the experts. And finally, there is a stage when the public is involved and we as a panel, we answer questions coming from the general public. This has been the format in Madrid and Rome. I expect it to be the standard format in the following meetings.
Thank you. So let us return to what you call the problem itself, to the ruling by the European Court of Justice. So what is your view on the European Court of Justice right to be forgotten ruling, and more broadly on the individual's right to privacy online?
So my view of the ruling is not very complex. It's just a little bit more orthogonal to the two campsites, as it were. Neither on the side of let's say, the European perspective, which seems to privilege privacy almost at any cost, nor am I on the side of the search engine, Google, which seems to privilege freedom of expression or freedom of speech, in more American terms, at all costs. Unfortunately, the issue is so complex that we should really think twice before jumping to conclusions. My particular perspective, not my point of view, is that the ruling in itself, the actual ruling in itself, was not a success. The Advocate General had a better opinion, which I wish the court had followed when ruling on this particular case. Having said that, the general principle, the overall perspective on how far search engines should be free to handle private and personal information, how many constraints should be available at the legislative level in order to make sure that there is competition, that there is fairness of treatment of personal data, that privacy is respected. Of course, these seem to me fundamental issues that need to be addressed properly. So here is the sort of almost unsatisfactory conclusion. On the one hand, I wish the ruling had been slightly different. On the other hand, it is thanks to the ruling, and I'm grateful for that we're actually dealing with the problem finally in all its complexity. So I think that the ruling had one major merit, which has to be recognized. And that merit is we now have to deal with the problem without having any chance of sort of hiding it behind other issues. The ruling itself, it seems to me to contain a lot of points that could be criticized. So I hope that in the future, the new legislation about data protection will take care of private data more successfully.
So can you maybe link to some of the points of criticism which you would find particularly worrisome or at least interesting to attend to?
So one, perhaps the point that I find most controversial is that in the ruling, in the specific case addressed, and the only case addressed by the European Court of Justice, the information in question, which concern a case that had been dealt with by Spanish courts about 16 years ago, had been published legally. It was, and it still is, available legally, and is completely truthful information. So it's something that there is no reason to consider inaccurate or infringing any copyright or improper in any sense. We're not talking about child pornography, we're not talking about infringement of copyright, we're not talking about inaccurate, improper information or information that has been taken from someone without any consent. This is a piece of information which is available to anyone who wants to find it. And that's where I find the ruling a little bit more controversial, because removing the link, one, does not solve the problem in and of itself. In other words, you can find that information anytime. Two, seems to delegate to the search engine now the responsibility of deciding what becomes and does not become available online. Now, this might have been always the case. I'm not saying that Google did not do this in the past, but now it's by law that we are expecting Google to decide about which links will or will not be available to the public, depending on the request that Google gets. And ultimately, we are limiting access to a piece of information online that is absolutely fine in any other respect. So what is the justification for removing that link, if not something that basically synthesizes the complexity of the case? It's very hard to do better than the European Court of Justice at the moment, given the legislation that we have, but I hope we will move forward.
Thank you. So, coming from the ruling itself to the implementation by Google, what do you think about Google's implementation of the ruling so far? For instance, about the search removal form, about the idea to use humans instead of algorithms to basically process the information removal requests on a case-by-case basis, etc. So
Google was, as they said explicitly, disappointed by the ruling, and I imagine they must have been. I think they were also astonished by the ruling. I don't think that they were expecting it either. That's my personal view. In terms of how Google has dealt with the ruling consequences, unfortunately, it can be seen in different ways. I personally think that it is something to be mildly appreciated. I don't think that what Google has done has to be taken as a major concession to the ruling itself. The ruling spoke only about that particular Spanish case. But I can see how Google might have wanted to anticipate problems and, in fact, try to get ahead of any consequences that may emerge from the ruling itself. So when Google provided that form, which we can all use in order to request the removal of a link concerning personal information online, etc., I've read different views about it as Google trying to push the case or make sure that the case will become almost ridiculous, or that as a way of doing some kind of public relations by forcing the hand of the European opinion against the ruling. Maybe there's some truth in that. But at the same time, I wonder how anyone defending the ruling may be against the availability of a form online through which each of us can actually now request the removal of that link. And I think that as a consequence of what we have seen so far, well, Google did the right thing by providing that form. The form can be criticized in its specific format, can be improved probably, but it's a good idea to have that form there, given the ruling as a sort of starting point. And secondly, as highlighted by your question, I think that Google is doing the right thing by having human beings, people like you and me, dealing with each case in its peculiarity. I would be surprised if we could develop an algorithm that would deal with every case automatically, no questions asked. What I think is the risk is that that could be the strategy. I mean, if you didn't care that much, you would just accept any request. After all, that doesn't dent Google's business very much or at all. Google gets all its profit from advertisement. Removing what at the moment are about 120,000 requests for roughly 500,000 links online, I doubt it would make any difference financially. So on the whole, I tend to appreciate what Google has done so far, with all the limits that I highlighted in my answer.
So let me turn to your role again as a philosopher and ethicist on this council. So what do you think can philosophy and ethics contribute, in particular, to the debate on the right to be forgotten, on the ruling, etc.?
I think the contribution from philosophy, ethics in particular, can be huge in this particular case, in this specific case, precisely because it's so complicated. If it were just a matter of a technological fix, or a legal modification of a particular clause in some kind of agreement. In other words, if it were a matter of discussing legally or technologically this issue, then of course philosophy would be out of place, the ethics would be probably playing a much more marginal role. But exactly because things are moving into uncharted territory, that's where we can do two things philosophically, ethically, better than many other, say, disciplines. One is understanding. I mean, this is a case in which we really need to think out of the box, and far from it, not only out of it, but leave the box completely, which means jumping into, if I may join the two metaphors, into this uncharted territory that I highlighted before, and try to think the not thought before sort of context. Now, this is where philosophy can help a lot. We need to be inventive, in other words, conceptually. The other aspect is, of course, finding not only understanding, but also a solution, trying to find a proper way of tackling this from the right corner. Now, we are, as a society, addressing issues that have developed so quickly and so deeply under our eyes that the deep thinking and the sort of strategic analysis that philosophy and ethics can provide is going to be pretty helpful. That's at least my impression when talking to people at Google, and that's probably why they invited a philosopher. They needed all the help they could possibly put together. Philosophy and ethics should definitely play a role.
What do you think is the most interesting philosophical question that you were exposed to in working on this ruling?
Well, I think that is this tension between privacy as a right and freedom of expression as a right on the other hand. It's like as if we had found in this particular spark, which is very small, the ruling by the European Court of Justice, a moment of confrontation between two huge fundamental human rights which we cherish, any side of the Atlantic, that we take seriously, both sides of the Atlantic, and that we tend to consider on the same level. Now, it would be remarkable, as I heard people saying, if we were to end up by privileging one right with respect to the other. I mean, rights are not in a sort of scale from 1 to 10. They are on the same line, like dots on a segment. They may be more or less related to each other, but there is no a dimensional hierarchy where privacy should trump on freedom of expression or vice versa. I heard people saying that, and officially. Now that worries me. So the deep thinking, the innovative thinking that we have to do philosophically is to discover how we can put these two rights together in a sort of harmonic relationship when in fact they don't seem to be clicking well these days when it comes to this particular ruling.
Basically, in another, so this reminds me a little bit of an article that you that was written in the Guardian on the debate between free speech and privacy not being a zero-sum game, and that we need to go beyond this World Cup mentality. In a different article, you argue that you argue for a proactive rather than a reactive debate. So, what could such a proactive debate look like, and what implications could this have for governance?
So let me address the first point about this is not a World Cup contest, this is not a boxing match. Unfortunately, partly I suspect also because of the context in which all this happened, there's been a tendency both on the political side and the mass media side to portray this as a big fight. It's easy to grasp. It's good against bad, it's Europe against US, is business against politics, is one right against, say, the financial interest of a big corporate agent, and so forth. Now, that doesn't help anybody, and it's not the case. It is not the case that on the one hand there are the good guys, and on the other hand they are the bad guys, and it's easy to disentangle right from wrong. Not at all. What we need to remember, as I said, is that this is a fundamental problem that was with us already decades ago. Sooner or later, these two fundamental rights, privacy and freedom of speech, freedom of expression, were going to intersect, and now we're just watching the clash. Perhaps we could have done something earlier. We didn't, and that's where the second point in your question pops up. In other words, the proactive approach. Since the audience is the big data journal, let me sort of illustrate this with a specific case. Now we're just moving in the big data context towards open access, transparency, especially when the data in question are government's data. Now, it seems to be obvious to anyone who thinks for a moment about this that there is a wealth of data that is becoming available to anyone who wants to exploit it. That's a good thing. However, who can exploit government's data? You, me, or the big corporate agent around the corner? Well, it seems to be obvious that if I provide zillions of data on, say, financial transactions, because the government wants to make that data, that big data, let's say, or in fact just call it open data, available to anyone, I think we should welcome the availability of that data to every single citizen in terms of transparency, responsibility, accountability of the authorities. But at the same time, I would be amazed if we were to provide free access to all, no matter what your business is with those data. That would be extraordinary, because we would be just giving away, once again, for free, to big commercial enterprises, something that you and I and any other taxpayer in every single country has put together through financial efforts. Now, that is a simple case, elementary example of something that we could do proactively in terms of thinking ahead. We are doing it as a matter of course. There are different philosophies in question here, for example, the transparency and accountability philosophy versus the innovative, the startup philosophy. Now, shall we do a little bit of thinking before opening up all this and allowing any company to exploit, say, European data massively without any charge? I don't think so. Back to the point that we're discussing today, if we had thought about this more carefully 20 years ago, or more concretely, just 10 years ago, when we were looking at this massive amount of information becoming available all over the place, there were no maps, no guidance. Now, times when, say, you and I and who's listening was using Alta Vista, or when the web was actually the internet, it wasn't the World Wide Web. Well, we could easily have predicted, and some of us did, that someone somewhere would have built the right gatekeeping, the right map, and would have charged for it in terms of either free products, but advertisement, or straightforward actually pay per usage. Something could have been done. We could have had not Google, but a European search engine, free for Europeans, free of advertisement, under public control. We didn't see it. We are now too late. Now that is something an opportunity that we have missed. When I say more proactive, I mean, let's talk about it and think about it before it happens.
Mm-hmm. One more question also on the labeling. You criticized that the ruling was labeled the right to be forgotten because you said the label is misleading. So what is the problem, and why is it misleading to call it the right to be forgotten?
The ruling, in fact, doesn't contain the expression, and there is no such thing as a right to be forgotten in any piece of legislation that we have at the moment. As I said, what we have is privacy understood in a particular way. It is a misname because it gives the wrong impression to the general public, that is used massively by the media, that somehow there's a way of erasing the past. We need to remember that what is in question is the activities of search engines. In other words, what we're talking about is the map, not the territory. It's the links, not the information behind the links. So no bits of information is ever removed in terms of so-called right to be forgotten. What is removed is the accessibility to that particular information, but the information remains available. So I think it's common agreement among experts that it would have been preferable to talk about all this in other terms. Unfortunately, the terminology now, it's what it is. Everybody understands the whole issue in terms of right to be forgotten. Google itself has, for example, named a advisory council in terms of advisory council to the right we've forgotten, and to the best of my understanding, that it's going to stick. But it's an unfortunate, misleading name.
On the notion of accessibility versus availability, another member of the Advisory Council, Jimmy Wales, has called the European ruling censorship. You take a very different perspective and argue that it's unhelpful to claim that this ruling invites censorship. Could you elaborate a bit on this?
Yes, it's another unfortunate use of a very loaded word, especially in Europe. If anyone has any recollection about history in this side of the Atlantic, or censorship has seen tragic moments in recent living memory history of many countries in Europe. So I will be very careful to speak about censorship as such. Let me just remind our audience that censorship happens, for example, politically, when information is actually removed, not just links. Censorship happens when information is manipulated so that bits of it disappear and other bits become more prominent. Again, most of the cases are for political reasons or for religious reasons, against the will of the people involved. But in this particular case, if you look at it, it is actually the gentleman from Spain who asked for that link to be removed, and it was a legitimate process from the highest court in Europe that allowed that process to go ahead. So censorship is an overloaded word that we should not throw around too easily. It doesn't help the dialogue.
So on the last question, your colleague at the Oxford Internet Institute, Victor Meyer-Schönberger, has argued for an expiry date for information. What do you think about this proposal? Which problems could be solved with such an expiry date, and which potential problems could not be solved with such a solution?
So an expiry date may seem to be a solution, and it probably is for some cases. In fact, there's already plenty of information that has an expiry date. Either physically, you cannot read those floppy disks anymore, and your CDs are disappearing, disintegrating as we speak. So there is a best before. Just remember that a DVD or a CD lasts about 7 years. So we don't even have to write on top of it best before. It's just going. There's also a lot of legally protected material, which say, for example, after a number of years, certainly in the States, but also in Europe, in terms of bankruptcy, is no longer available. So after a few years, that information is no longer something that anyone can have access to. So to some extent, this is already happening. I would be very reluctant to adopt a best before or a general strategy in terms of expiry date for information as such in general. If that were the case, we wouldn't know about the Roman Empire, we wouldn't know about the history of Europe the day that all this clicks. I think it's unfortunate that we live in a context where we expect digital information to last forever, not true, and we expect digital information to be accessible anytime, anywhere, to anybody without any consequences, not true either. There is a sort of realignment of our expectations that we have to work on. Digital information is very fragile on the one hand, and can be very dangerous on the other hand. If we realign our expectations, then we have a better chance to deal with both problems.
Thank you very much for this interview.
Thank you.